Hello! In this video, we're going to be discussing some highly tested areas of law on the Uniform Bar Exam. Specifically, these areas of law that we have picked out are not only highly tested on the MEE portion or the essay portion of the exam, but they are also highly tested on the MBE portion of the exam. The first subject that I would like to talk about is civil procedure. Civil procedure is the most highly tested subject on the MEE portion of the exam. And when they test civil procedure on the MEE, they like to test things like subject matter jurisdiction, personal jurisdiction, as well as transferring between venues. So first, let's talk about subject matter jurisdiction. Subject matter jurisdiction is the court's power to hear that type of case. The court has to have subject matter jurisdiction. If the court does not have subject matter jurisdiction, they have to dismiss the action. This is not something that is, say, consentable, like personal jurisdiction. It's also good to remember that subject matter jurisdiction can be brought up and discussed at any moment in time in the proceeding, meaning parties can litigate a matter and then take up subject matter jurisdiction for the very first time on appeal, and that is completely fine and appropriate under the rules. It's also good to know the different kinds of subject matter jurisdiction: federal question, diversity jurisdiction, and supplemental. Remember, with federal question, that means that the issue being brought before the court arises under the Constitution or under federal law. Or it may arise under state law, but it relies on a substantial federal question. Diversity jurisdiction is this scenario where the parties are completely diverse from one another at the time in which the lawsuit is filed or commenced. We look at the parties' domicile to determine whether or not they are in fact diverse. The other requirement of diversity jurisdiction is that the amount in controversy must exceed $75,000. Finally, supplemental jurisdiction is the idea that the court might have power to hear one part of the case, and so long as the issues in the case arise from the same common nucleus of operative fact, the court can then hear the other issues in that case. For instance, if you have a federal question pending in front of a federal court, you can tack on a state law issue that arises from the same common nucleus of operative fact. So while the court might not generally have subject matter jurisdiction over that state law claim, you could tack it on to that properly filed federal question. My little word of advice for you on the MEE: if your MEE is testing subject matter jurisdiction and you feel like supplemental jurisdiction is the correct answer, be sure that you first discuss subject matter jurisdiction in the context of diversity and federal question before you move on to the discussion of supplemental jurisdiction. We find that many MEE analysis talk about the other forms of subject matter jurisdiction before they land on and discuss supplemental jurisdiction. Moving on to personal jurisdiction. This is tested once every few years, and there is a trend towards testing specific jurisdiction. Remember, if they do test specific jurisdiction, you want to mention that both the state's long-arm statute has to consent to the state's exercise of power over the person, as well as the United States Constitution has to also okay the state's exercise of power or jurisdiction over the person. So here you want to talk about minimum contacts. Look for the defendant or the person in question purposely availing themselves to the benefits and protections of the state at issue. Then move on to discuss the quality of the contacts in which that person has with the place. Lastly, remember what the definition of personal jurisdiction is. Personal jurisdiction is the court's power over the person. There is both general and specific personal jurisdiction, and this is something that is consentable, meaning if you are sued in the wrong place and you fail to object to it, the court can go ahead and exercise power over you. That is fine. That is unlike subject matter jurisdiction. Then finally, another very highly tested issue on the MEEs is transfer to a more appropriate forum. So here the federal court has authority to transfer a case to another federal district court for the convenience of the parties and witnesses and in the interests of justice. The new forum must also have subject matter jurisdiction and personal jurisdiction over the parties as well. When this happens, the court will apply the law of the transferor forum. So to clarify this, if I file my lawsuit in the correct venue, But we all decide, and the court specifically decides, that there is a more convenient place for us to litigate this issue. The court can then transfer our lawsuit to that more convenient place for us to litigate. However, in order for that to happen appropriately under the rules, that place in which our case is transferred to must also have personal and subject matter jurisdiction. Additionally, if there's any sort of question about which law is applied to the case, the law of the transferor court, or the court in which the lawsuit was originally and properly filed, will apply to this lawsuit. The other thing I want to discuss with civil procedure is that it is also highly tested, of course, on the MBE. And what I mean by that is 25 of your scored 200 questions will come from civil procedure specifically. And within those scored 25 questions, 5 to 6 of those scored questions come from jurisdiction and venue alone. So the reason I'm highlighting that is because not only will you see 5 to 6 jurisdiction and venue questions on the MBE, but you will also, more likely than not, encounter one of those issues on the MEE portion, since they are rather highly tested there too. The next subject that I would like to talk about is constitutional law. So common law is rather highly tested on the MEE, and it also, of course, comes up on the MBE. So let's talk about those highly tested issues on the MEE. First of all, we see lots of free speech questions. A few times free speech has been tested in the context of a trespass or a criminal claim, but not every single time. The other thing that's really important to keep in mind about speech is that you want to be familiar with all of the different tests. And I know that this is something that a lot of examinees struggle with because they already have a lot to memorize, and there are some smaller moving pieces here that they, of course, have to memorize and solidify to be able to put down and accurately analyze an issue on the MEE. But it is good to familiarize yourself with what is content-based restrictions or regulations, what is viewpoint-based, and then, of course, be familiar with time, place, manner restrictions and tests. The other great thing about free speech, and the reason it is worth your time in studying and paying close attention to, because not only is it heavily tested on the MEE portion of the exam, but individual rights on the MBE portion make up 12 to 13 of your scored 25 questions on the MBE. So that is the most highly tested subsection of constitutional law on the MBE, and free speech falls within the individual rights category. So again, it would behoove you to know it not only for the essay portion, but also for the MBE portion as well. Oftentimes people ask us, what does individual rights technically encompass? What should I be looking at when I see that it is 12 to 13 of my scored 25 questions? And individual rights for MBE purposes encompasses due process, both procedural and substantive, as well as equal protection clause issues, as well as First Amendment. So of course that means religious issues and speech as well. It's also good to be familiar with the fact that Congress has the power to regulate interstate commerce for purposes of the MEE. So when a state attempts to regulate interstate commerce, absent from some sort of congressional regulation or intent, we use one of two tests to determine whether or not the state action in question is going to be constitutionally permissible. If the law is discriminatory on its face, strict scrutiny is used and the law is usually struck down. So when we say discriminatory on its face, we mean when you read it, you can tell that its purpose is to say favor in-state versus out-of-state. If you see that type of law, the state is attempting to act as a protectionist, and we do not like that. Apply strict scrutiny and strike it down. However, if the law is neutral and attempting to treat both in-state and out-of-state equally, meaning it's putting a burden on interstate commerce but not necessarily acting as a protectionist, here we're going to use a balancing test to determine whether or not the law is constitutional. This means that a law that is subject to the balancing test is more likely than not to be upheld. So when we do this balancing test, we look at the type of burden that is being placed on interstate commerce, and we balance that up against the type of benefit in which the state is receiving from this law that has been passed. And then another thing to be familiar with for purposes of constitutional law in the MEE is that Congress cannot commandeer states, meaning they cannot force states to enforce federal laws. Congress either has to regulate the states directly, meaning it has to fall within one of congressional powers, for instance, like the commerce power, or regulate them indirectly by threatening to take away some of their funding if they do not adopt the law. And they would again do this pursuant to a congressional power, specifically their spending power. So that wraps up constitutional law and how it is highly tested both on the MBE and MEE parts of your exam. The next thing that I want to talk about is contracts and sales. So contracts and sales is not only tested highly on the MEE, but also it is 25 of your scored questions on the MBE portion of the exam. Specifically on the MBE portion of the exam, we know that formation of contracts makes up 6 to 7 of your scored 25 questions. Additionally, performance, breach, and discharge also makes up 6 to 7 of your scored 25 questions, meaning this makes up, those two sections together make up somewhere between 12 to 14 of your scored 25 questions. It's the most highly tested areas of contracts on the MBE portion of the exam. Additionally, for the MEE, contract formation is quite heavily tested. Beware of all of the nuances and the smaller moving pieces of your basic elements of a contract, which of course is offer, acceptance, and consideration. So for instance, the MEE is not going to test contract formation in a super straightforward way. Instead, they want you to have a really good definition about what is offer, what is acceptance, and what is consideration. And they might test whether or not an offer is lapsed or whether or not an offer could be revoked. So again, you want to make sure that you understand the ins and outs of these elements so that you can talk about them if the essay tends to test one of those things specifically. Additionally, damages for breach of contract has come up on the MEE portion of the exam. And as I highlighted previously, this is something that can, of course, be tested on the MBE portion of the exam. So if you see some sort of damages question on the essay portion, I would start my MEE by stating the normal measure of damages for breach of contract is expectation damages, which aims to give the non-breaching party the benefit of the bargain. Remember that expectation damages must be foreseeable and proved with reasonable certainty. This is very similar to our Uniform Commercial Code rule, which puts the aggrieved party in as good of a position as if the other party had fully performed its obligations under the contract. So that wraps up contracts and sales for us. The next area of law that's highly tested between both the MEE and MBE portion of the exam is evidence. So when it comes to the MBE portion of the exam, relevancy and reasons for excluding relevant evidence makes up 8 to 9 of our scored 25 questions. Additionally, hearsay makes up 6 to 7 of our scored 25 questions. So these are two areas that you want to be very familiar with for purposes of the MBE. When it comes to the most highly tested issues on the MEE, they also like hearsay. So make sure that you are able to define hearsay. Remember that this is an out-of-court statement offered to prove the truth of the matter asserted. Then be familiar with some of those more highly tested areas of non-hearsay and hearsay exclusions. Be familiar with the elements of those so that you can talk about them intelligently on an essay and, of course, analyze them thoroughly and appropriately based on the fact pattern presented. Some of those highly tested exclusions and exceptions are things like party admission, present sense impression, excited utterances, statements made for the purposes of medical treatment or diagnosis, and business records. Those are things that, again, I would be very familiar with. Other highly tested areas of the MEE are things like impeachment. So as a reminder, remember that anyone can impeach any witness. So say you are counsel for plaintiff and you call a witness to the stand and that witness starts testifying in an odd way, you can move to impeach that witness. So anyone can impeach any witness. I would be familiar with the 7 ways in which you can impeach someone. I would simply memorize those. That way, if you see something like that happening on a fact pattern, you can quickly identify it. And again, that's going to be helpful for you to know for MBE purposes. And additionally, when it comes to impeachment, the other thing that they like to test is whether or not extrinsic evidence can be used to help aid in the impeachment process. Extrinsic evidence simply means outside evidence. For instance, like could they use a document or something like that to help aid in the impeachment process? So I would be familiar with those types of nuances as well. And then finally, character evidence. Character evidence is highly tested as well. So it's something to be familiar with for both the MBE and MEE purposes. The general rule is that character evidence is inadmissible to prove that someone acted in accordance with their character at the time in which an event occurred. Usually for MEE purposes, character evidence is tested in the context of a criminal case. And remember that in a criminal case, defendant holds a lot of power. Prosecutor cannot offer character evidence in their case in chief. We have to wait for defendant to open the door and offer in character evidence of their pertinent or relevant character traits. And they can do this by putting a witness on the stand to testify in the form of reputation or opinion regarding those character traits. Once defendant has opened that door, plaintiff or prosecutor, I should say more specifically, can also then try to rebut that and offer in character evidence. Prosecutor can do this by also putting up a witness to testify in the form of reputation or opinion. And they can also cross-examine defendant's witnesses by inquiring into specific acts. So that is something that defendant cannot do, but that the prosecutor can do. And then the last subject that I want to talk about in terms of the highly tested areas on both the MEE and the MBE is torts. So when it comes to torts on the MBE portion of the exam, we know that negligence makes up 12 to 13 of our scored 25 questions. It is the most highly tested area of torts on the MBE. In fact, this means it makes up 6 to 7% of your total MBE exam. It's an area that you want to be very familiar with, and I would make it your first focus when you approach torts. Additionally, negligence is very highly tested on the MEE portion of the exam. So again, you benefit from focusing on this for both the written and multiple choice portion of this exam. Additionally, they really like to test premises liability in the context of negligence on the MEE. So be very familiar, of course, with the elements of negligence, duty, breach, both types of causation, actual causation, as well as proximate causation, as well as damages or harm. Be sure that you can distinguish between who is a trespasser, who's an invitee, as well as who's a licensee, and the duty of care that's owed to each. My little tip for you here is if you are faced with some sort of premises liability issue on the MEE, and maybe one of the people in the fact pattern could possibly be categorized as, say, a trespasser or maybe a licensee. Be sure that you talk about both types of statuses that person could be classified as, and talk about the duty of cares associated with each of those statuses. We find that sometimes when they test premises liability, they do want you to talk about everything that's applicable based on those facts. Sometimes intentional torts are tested on the MEE, and as you know, intentional torts can be tested on the MBE, but it is not as highly tested as negligence. I would be familiar with the elements of assault and battery. I know a lot of people can kind of work their way through an MBE problem with those issues, but they have a harder time writing them down and analyzing them in writing. So be sure that you know what assault is and battery is. Remember, they're basically the same thing, just the harm is different. Battery is when defendant acts with the intent to cause harmful or offensive contact, and harmful or offensive contact directly or indirectly results. Assault is the same thing, except imminent apprehension results. Finally, vicarious liability is heavily tested in the context of torts on the MEE. Please understand that when an employer is liable and when the employer is able to seek indemnification for damages that are paid to plaintiff on behalf of a negligent employee. Remember that indemnification means full reimbursement for damages that are paid to a plaintiff. This is when your defendant can seek 100% of the damages from the other defendant. And again, this usually happens in the context of an employee and employer-like relationship, where the employer is sued simply by virtue of the relationship that they have with the truly negligent or guilty party. And of course, usually employers have deeper pockets than employees, so usually they're the first to pay out. If they do that, they can turn and go after the truly negligent party or the employee, for instance, for all of the damages that they've paid out to that plaintiff. So that wraps up our highly tested issues on the Uniform Bar Exam, and we hope that you found it helpful.